And welcome again to today's webinar, Contract to Closing, Protecting Your Clients and Their Money from Cyber Fraud. In case you were not here earlier with technical difficulties, I'm Ashley Black and I'm today's moderator. I've been practicing residential real estate here in the Triangle for over 10 years, and I'm currently a partner at Ragsdale Liggett. I'm also a board member of Relink. Will someone type in and let us know if you can hear us? And also let us know if it's very crackly, because the tech people here are letting me know that we might be able to make some changes that would help with that. In the meantime, we can discuss how great Relink is. It's the real estate lawyers of North Carolina, and they are responsible for today's webinar. Well, before introducing our panelists, we're going to take care of some housekeeping items while we also work on the technical difficulties. Please note that today's webinar does not currently qualify for any continuing education credits for real estate brokers, lawyers, or paralegals. However, law firms should note that compliance with best practices pillars 2 and 3 do require regular training for staff, and today's webinar should be counted as such training. For all those tuning in today, and hopefully you can hear me, please note that you may write in questions to us during the presentation. If your question is not answered during the presentation, we will answer it at the end as time allows, or follow up with you after today's presentation. I'm hearing from my staff that they cannot hear me. So again, I'm Ashley Black, and we will now go around and have the panelists introduce themselves. Troy.
Hello, I'm Troy Crawford with Lawyers Council. I am a claims attorney that handles primarily real estate claims and chair our Data Security and Privacy Committee. I also handle most of the claims that come in that are related to wire fraud.
Hi, I'm Janet Thoren, Legal Counsel and Director of the Regulatory Affairs Division for the North Carolina Real Estate Commission. I've been with them for almost 20 years.
As far as the phone will go.
The Commission licenses, regulates, and educates about 100,000 real estate brokers in North Carolina.
Hi, I'm Keith Polak. I'm Trust Account Compliance Counsel with the North Carolina State Bar. Cover all sorts of trust accounting issues with lawyers in North Carolina.
All right, I am getting information that we need to speak into the microphone louder. In addition, if your office has not put this on mute, please do so. Today we have over 300 participants, which include real estate brokers, real estate attorneys, and their staff. Troy, why is it necessary to bring these groups together to discuss wire fraud prevention?
Thank you for the question, and the basic reason is either we can work together to stop these from happening, or we're going to have to fight over who's responsible when there's a lawsuit. Right now we're seeing about 5 or 6 of these every month that are happening across the state of North Carolina, and it is the biggest problem that ever faced the real estate bar, and I would say the real estate industry also. We have tried working separately, it's not working, and hopefully if we can come together, we'll be able to get a better solution.
Janet, speaking loudly into that microphone, can you discuss why wire fraud prevention is important to real estate brokers?
Sure. Lawyers are already feeling it, and lawyers have developed better systems for catching and preventing this type of fraud. Brokers are just becoming aware of the issue, and they are now the more common target, with phone emails being compromised and hijacked. Despite numerous warnings issued over the last several years by the real estate industry and consumer groups and the news media, many brokers still seem surprised when they hear about these wire fraud scams. Just being aware of the problem and taking steps to prevent this kind of fraud is extremely crucial for all of our brokers for a number of reasons. First, I'd say real estate brokers are often the first point of contact for the buyers and sellers in the real estate transaction, and they're right in the middle of the transaction the entire way through. Second, they have most of the communication with the buyers or the sellers, far more than any of the other professionals involved in limited parts of the transaction. Finally, real estate brokers like to control the transaction all the way through. They are often the ones transmitting information back and forth between their client, other professionals involved in the transaction. So they're the perfect source of most of the information necessary to commit this kind of wire fraud. Brokers often use free email accounts with little or no security measures. They use public Wi-Fi when they're meeting clients in coffee shops or in other public places. And with all of the information that they possess and they transfer electronically, often not using adequate security, they're clearly the weakest link in the chain at this point in time.
Janet, thank you for that information about the real estate agents. And if you have not done so already, please go ahead and mute your phone while we continue to work on muting all attendees. I'm a real estate attorney here in North Carolina, and as Janet mentioned, I think that it's so important for us all to work together to prevent wire fraud, especially with these agents who have so much contact and our main source of contact with our clients. We want to help keep the closing process smooth and easy for both the agents and our clients. However, it is a fine line between protecting the client and overwhelming the client with wire fraud information. Regardless, our number one concern is safeguarding our clients' funds. And over the past 2 or 3 years, I think law firms have made numerous changes to their procedures to protect clients' funds. Lawyers, in addition to wanting to protect those client funds, we do not want to run afoul of the state bar. And we have Peter Bolak here today. He's a trust account compliance attorney for the state bar. Peter, why is wire fraud prevention important to the state bar?
Thank you, Ashley. The state bar is, the purpose of the state bar is to regulate the legal profession for the protection of the public. We're not the North Carolina Bar Association. Our first interest is not lawyer protection, it is the protection of the public. And these wire fraud scams that are causing such losses to both lawyers and clients is directly related to our mission to protect the public. Trying to stop these scams is, on the front end, stop lawyers from falling for these scams certainly helps us keep the public protected.
Yeah.
And dealing with them after they've happened is also important for the bar to make sure that clients are made whole and don't suffer any losses from these types of scams as best they can. One thing we've also seen is this is, as Troy pointed out earlier, this is probably the most concerning thing it's definitely the most concerning thing I've seen since I've been at the bar, and anyone else related to trust accounts and money would agree. This is the scariest thing that's hit the bar that in recent memory, that has come to the point where it could be possibly an existential risk on lawyers having the right to hold client money and deal with entrusted funds. If we can't get a grip on this situation, there's certainly the potential that our ability to hold client funds and deal with entrusted funds is going to be jeopardized. There's also somewhat of an existential risk for the right of self-regulation. If we can't, as a profession, get a hold of this ourselves, there's always the risk that the right of regulating ourselves can be taken away. We've seen that potential risk play out in the legislature for other things, and so we are not necessarily guaranteed that right of self-regulation, and stopping these types of scams is important to keep that right. One thing I will point out to lawyers is that in recent quarters, the State Bar's Grievance Committee that handles all of the discipline for lawyers across the state has shown a new willingness to impose professional discipline on lawyers who fall for these scams if they did not satisfy a reasonableness standard of having reasonable safety measures and security measures in their firm to stop against this type of fraud. I wanted to point out a lawyer's duty on the next slide here. The State Bar in 2011 issued guidance about a lawyer's duties as it relates to online banking and technological security. In Formal Ethics Opinion 2011, that was deals with lawyers dealing with using online banking to manage a trust account, does state that a lawyer must use reasonable care to minimize the risks to client funds on deposit in the trust account, and it did give the lawyer some affirmative duties. So this is something that lawyers have to be making sure that is happening in their law firm and in their office and with any employees that are dealing with the trust account. That is to stay regularly educated as to the security risks, actively maintain end-user security. So that's dealing with passwords, that's
yeah, but I
dealing
can
with
barely hear it
who
on
has
my phone.
access to the online banking, who can initiate wires, who can send wires, and then ensure that all staff members who assist with the management of the trust account are also receiving training and abide by the firm's security measures. These are the types of things that you need to do as a lawyer to be able to say you are using reasonable care to minimize the risk of funds on deposit. The opinion did not lay out any specific requirements for lawyers because this is always such an ever-changing environment. What might be reasonable today will soon become unreasonable next year when a new scam comes about, but we did lay out those affirmative duties of a lawyer to deal with it. Fulfill your fiduciary obligation to safeguard client funds by applying the same diligence and competency to manage the risks of online banking that a lawyer is required to apply when representing clients. And as an example, just this August, at the July meeting of the State Bar Council, there was discipline imposed. Now it only rose to the level of a letter of caution at this point, but this is a kind of a milestone here where there's discipline imposed just for a lawyer becoming a victim of this wire fraud because the lawyer did not take reasonable security measures under Rule 1.15 to determine the genuineness of the imposter's emails, and as a result, the proceeds that should have been dispersed to the real seller was dispersed to the imposter's account. Now, this is a dismissal with a letter of caution, but it's certainly the first step of the grievance committee deciding that professional discipline is warranted for a lawyer not being reasonable in these circumstances.
Thank you.
We're having a hard time hearing you.
And hopefully all the lawyers on here today have their staff with them, because I think while we get this information, we're not always very diligent about passing it on to our staff. Please, everyone know that the tech support here is working to mute all attendees, but until that point, if you have not muted, please do so. People can hear you rustling your papers and talking to your secretary. That's awkward. So let's go on to Troy. Troy, here at Lawyers Mutual, you have probably heard of all sorts of scams against real estate brokers and attorneys. Can you tell us some of the characteristics of a wire fraud scam?
Yes, I'll be glad to. Most of these scams, first of all, they are constantly changing. They're getting more and more sophisticated. But they all share one thing in common, and that is a compromised email account. Sometimes it's the closing attorney that's email is compromised. Sometimes it is the real estate broker's email that's compromised. And those two groups are specifically targeted. However, it can be the individual clients, the buyers and sellers themselves, that have email compromises. That being said, what I would like to do is just tell you the way these things first started coming into the office, and that was primarily when the seller's proceeds were being hijacked. Specifically, it started out, there would be a typical closing scenario, and then sometimes shortly after closing, the closing attorney would receive an email requesting the proceeds, whether they're being picked up by check, to be wired, or maybe to switch accounts due to some type of banking problem. The State Bar worked very hard, as did Lawyers Mutual and as did all the title companies, to try to educate members of the bar as much as possible. And fortunately, those have, for the most part, dropped off. We're not seeing many of those. They're probably only about 10% of the closings we're seeing. What is taken over and what is dominating the frauds now are situations in which buyers' incoming proceeds are being hijacked. Typically, in that scenario, the fraudsters are monitoring the email accounts of either their closing attorneys or the real estate brokers. They're waiting until a big transaction's coming in with either it's a cash closing or a very substantial down payment, and then they're directing the buyer to wire the funds to a fraudulent account. Now, what's significant about that is the buyers, typically speaking, are not nearly as sophisticated as the parties, the brokers and the attorneys. And we have not done a good job as a profession in educating our end clients on what to do with the funds. We have seen these where The hackers will actually not just set up fraudulent accounts, but they'll actually take over someone's account because of improper email security. And so rules will be set in inboxes where the broker or the attorney will not even see the wire, will not even see emails. They'll go to subfolders where only the fraudster can read them, and then they will communicate directly with the client. In those situations, we know about $4 million over the last 6 months that was diverted from North Carolina. And again, that's only what we're informed of. That is not matters that have not been reported to us. Maybe the FBI has better numbers, but right now we know about $4 million in the last 6 months of incoming earnest money deposit, incoming cash to close funds that have been hijacked.
Wow, that's a lot of money. Janet, for all those real estate brokers that are tuning in and hearing these horror stories, what are ways that they can help prevent wire fraud?
That's a great question, Ashley. First, brokers should really avoid using the free web-based email accounts like AOL or Yahoo. I know that's going to send a shockwave through the brokerage community, but some of these accounts, there are some accounts like Gmail that allow you to encrypt your email or use enhanced security features like additional forms of authentication. If a real estate broker is insisting on using these types of email accounts rather than a paid account that's secure, they should learn and use the additional security features that may be offered through their account. They should also set up systems to require them to change their passwords often and not use the same passwords for email and other electronic transaction programs they use like DocuSign or other programs. We've actually had some situations where DocuSign has been hacked into and things have been changed as a result of that, or information has been gathered because of that. So you need to be careful about not using the same passwords for everything that you access. Also, we're telling brokers be careful not to open attachments or click on links from unfamiliar sources. This is how malware is usually spread, or it may be some phishing scheme, and a broker may have no idea that by clicking on a link or an attachment, they have just let a hacker into their system. Also, we're trying to let our brokers know that we're educating our brokers. They need to educate their clients. Clients should be advised to look at their emails very closely for anything that might indicate that the email is fraudulent. They should tell their clients never to wire money based on an email alone. There should always be some other verification before clients are wiring money from their bank account anywhere. In addition, brokers need to change the way that they serve their clients. They need to move away from being that center point of the transaction for contact purposes between clients and lenders, or clients and the attorneys once those relationships are established. Lenders and attorneys have already set up secure systems for handling a lot of these issues, and right now the brokers are the weak link, like I said. So the attorney needs to know who their clients are, and the clients need to know the attorneys. Same for the lenders. Brokers really have no business in this day and age communicating wire instructions back and forth, and they should make it clear that all of those types of communications will be directly between the attorney and the client only. Learning to stay out of that part of the transaction will help them to keep their clients safer. Another thing that brokers can do is to be careful when their clients ask for a referral for an attorney for closing. Brokers tend to want to refer their clients to attorneys who they know will do things the way the broker likes to have them done, whether that means violating rules of professional conduct or however the lawyer may be handling the transaction. It's the way the broker likes it, so that's the attorney that gets on their list. That's not always what's best for the client. First, if brokers are referring to any other professionals, they ought to always refer 3 or more names and allow the client to choose the professional. When they're referring a closing attorney in particular, the broker should refer to attorneys who have systems in place to secure a client's transaction information, like encrypted emails and good wire verification protocols. A good attorney who has looked at this issue and is on top of it will be happy to discuss their security measures with brokers because they're going to want that business.
Janet, one of the things that we do at our firm is we definitely try to help take the real estate agent out of the communication of wiring instructions, like you mentioned. We want to protect our client. We also want to protect the real estate agent, and we just let them know that we will be sending the wiring instructions directly to the client through a secure email. And that's just one of the many things that we do to help prevent wire fraud. But Peter, what are some of the other steps that the State Bar recommends attorneys to take to avoid wire fraud?
Sure. We have a lot of recommendations for lawyers to protect against this fraud, but I wanted to jump back to something that Janet mentioned about attorney referrals. One of the other scams that we're seeing still existing around are the attempted cash buys or purchases from someone who lives in Asia and wants to come retire here in North Carolina and wants to buy a house sight unseen, and I'm going to be sending you earnest money of $30,000. Can you find me a lawyer or refer me to a lawyer to hold my money for me? I just had one of those come up just last week as someone asking if it was a scam. And on a side note, every time a lawyer has asked me if something was a scam, it's been a scam, 100% of the time. So please just trust your gut on that one. If it feels too good to be true, it is. But these out-of-state ones, they get the lawyers, they dupe the lawyers because they're not being contacted by the so-called client in Asia. They're being contacted by a real estate broker in their town that they deal with and that they trust. And so that's another issue about being careful when making attorney referrals. Just to know that when an attorney gets something from a real estate broker, they want to honor it and be helpful with it because they want to consistently be contacted and called on when that broker is trying to find a lawyer for a closing. So just keep that in mind when you're doing these attorney referrals, that they're trying, lawyers are unfortunately giving too much good faith all the time on what they're hearing. But in terms of some recommendations for protecting against this wire fraud, these are the standard ones that you've probably heard all of the time. Confirming all wire instructions with a phone call or some sort of secondary contact to a known good contact number that the lawyer initiates. This is the first scam that we heard about 2 years ago when this first started to pop up. The law firm had a system in place where they wanted to verify the email that they received, but they allowed a phone call that was incoming to the law firm to verify the email to count as their authentication. And so really what happened was the hacker both emailed the law firm and then was the caller to the law firm to say, hey, I just emailed you my new wire instructions. And they treated that as authentic. Whereas this needs to be done by the lawyer initiating the call to a phone number that they know is good, not a number that's in the email, because that number in the email is also going to be the number that is likely to go right to the hacker or the fraudster. So there needs to be a number that is in your file that you know is to be good, that's been in use, or that was given to you, filled out by hand by the client, or whatever it is that you know to be the right contact number. To try to stop against this new wave of attacks that are going directly towards buyers, lawyers should be using, and if I know these are recommendations because we can't make any specific requirements like this that aren't in our rules, but lawyers should be having something in their signature blocks or when they're contacting clients that says if you're getting an email requesting wires or containing wire instructions from us or from anyone, you need to call us at our law firm number to verify that we really did send this to you, because there's always the chance that it's someone else trying to portray us. And again, that same phone number kind of advice applies, that you would want them to use a number that is, look up the law firm's number and not just use the number that is provided in the email. The early ones of these scams, early instances of these scams involved spoofing email addresses that were just 1 or 2 letters off. They certainly now talk about actually hacking the email accounts and using the actual seller and buyer's email accounts. But the early ones did have little letters or little minor differences to email accounts, so always be on the lookout for that. I know we're going to talk about here later some insurance options and all the, how this relates to insurance, but consider cyber insurance and different policies, but we recommend just to make sure you know what you're buying and what you're getting into and what your protections are. There are a lot of different types of companies offering policies on cyber insurance that they call cyber insurance, but they aren't protecting against this type of scam, or they're not protecting against counterfeit check scams. They're only protecting against direct hacks or other types of losses, and so you just need to know what you're actually being covered for. Having multiple eyes on these situations is crucial. Having people in your office reviewing instructions or before initiating wires is really important, so it's not just falling on one person. Have some sort of error margin there. One thing I used to tell lawyers and still do is just change it up a bit, to consider some sort of agreed upon password that you've told a client that it's never been sent over email, that's either only been delivered when you meet with them, or that's been on paper, that when you've talked with them, that when you call to verify something from a client, you ask them to, tell you the password that you two have agreed upon to be able to verify who it is you're dealing with. I used to call that a safe word, and I think that creeps some people out, so I've changed it back to being called just a password. And then finally, really, and what I ultimately get down to when I talk to lawyers about this is just say no to this. If someone's calling to email, if someone emails you to change the method of disbursement, say, I would rather, here's our new wire instructions, we'd rather go to this account, or I know that you were going to send me a check, but I'd rather you wire it to this account instead. Say, sorry, we can't do that right now. It's too dangerous. We're going to have to follow what we've agreed upon, or you're going to need to come in and execute a new agreement on how you want this to be distributed. That is really just the safest manner, because a lot of the first iterations of these scams were just changing disbursement methods at the last minute that were being honored by the law firms. And so this is something that you really just, at this point, I don't know that you could be comfortable dealing with without some sort of in-person, change and agreement.
All right. Well, let's all assume that despite everyone's best efforts, that the real estate agents have followed all of Janet's suggestions and the attorneys have followed all of Peter's suggestions. We've done everything we possibly can, but we're still a victim of a wire fraud scam. Troy, what should we do to minimize the harm?
Well, thank you. And timing is the absolute key. The top bullet point there talks about the 24, 48-hour observation, and that used to be pretty absolute until a couple of things the last week. But generally speaking, if the fraud is discovered within 24 hours of the wire being transmitted, we have great success in getting the majority of the funds returned. Not always, but generally speaking, if we can catch it within one business day, we've been able to get accounts frozen and the funds eventually returned. Now, I do want to make clear that sometimes it will take several weeks for the funds to be returned, and the state bar is probably not going to be happy with the client's money sitting out there or your trust account being upside down, depending upon how it was done. So there's still a lot of problems, but the money will eventually come back, and that's a great thing. Generally speaking, if it's been more than 2 business days since the wire was transmitted, the amount of recovery we're receiving is not nearly as substantial. Sometimes 10 or 15%, if not less, of the funds are remaining after 48 hours. So jumping on it right away is key. And whenever we have claims, if you go to any seminars that insurance people do, they always say, call your insurance company, call your insurance company. And this is the one time that we're saying, don't call the insurance company right away. The first phone call, one person in the office should be calling your bank, and another person in the office should be calling the bank that the wire was sent to. Now, the higher up the bank chain of command you can go, the more successful you are. The teller line is probably not going to help you too much, but at least get the process started and hoping people will flag accounts in there. After those people are contacted, then it's time to start calling your insurance companies, both your errors and omissions coverage, and hopefully you have some type of crime or cyber policy, and they can jump in. One thing that we do in situations like this is that we have banking counsel that is able to call real people at Bank of America and Wells Fargo and your other national lenders, and they'll actually answer the phone calls. It's something that's kind of frustrating for me because I have the contact information for the people. I have their emails. I have their phone numbers. But if I email or call, they don't get the results. However, we have a couple of attorneys that are able to get them to pick up the phone and freeze accounts right away. And that is key. Also, contact law enforcement. The FBI requests all reports go through the ic3.gov website. That information is readily available. It's ic3.gov, and they ask that all things be reported there. Even minor things are attempted hacks, just for statistical gathering purposes, and they're getting a lot more sophisticated. Now, I mentioned that our counsel was very good about getting bank accounts frozen. The FBI is even more serious, because when the FBI calls, everybody picks up the telephone. And so if we are able to get the FBI to jump in right away, they're usually able to do that. Now, after we've done the triage and stopped the wires or frozen the accounts to the extent there are funds left, the next thing is we need to figure out what happened, because the vulnerability that caused the original hack is still out there. And if it's the attorney, for example, that the fraudster now knows that you're sending and receiving large amounts of money that are coming into your account. And so the first thing you do after the immediate rush is over with is you start looking into what happened. And it's time to call an IT professional at that point in time, someone that can come into your system and take a look to see if your IT logs, your IP logs, is someone accessing your account from Belarus. Unless you are visiting White Russia, there's probably no reason for someone from Belarus to have to gain access to your account. Same thing goes for your email. Are there misdirects? Are there folders set up? Things of that nature. And so there's things that you can do right away to see where the hack is coming out there. Also, if it turns out it was the real estate broker or it was the attorney that was compromised, the way these scams are working is that people's accounts are being monitored for a significant period of time. So not just this one particular client has had their emails read. A whole bunch of other emails have been read. And so looking at when the compromise first happened and potentially seeing what emails have been compromised, you may need to let the clients know. You also need to let everyone else know that right now they're not to send any wires to any account until we can trace what's happening. That is very, very key.
Great advice, and thank you, Troy. Let's hope none of us need to use that advice, but in the event that we do want to talk next about the potential consequences if we are a victim of wire fraud. And Janet and I have been talking earlier, and we think one of the most significant consequences for closing attorneys and real estate brokers would be the damage to our reputation. Who wants to use a real estate attorney or a real estate broker that's been compromised by a wire fraud scam? Janet, can you discuss some other consequences real estate brokers might face?
Sure, I'd be happy to. If the broker is the weak link, the one who was hacked, there could be some significant repercussions for that broker. Brokers owe fiduciary duties to their clients, and a breach of security that amounts to a loss of someone's life savings could ruin that broker's reputation, like you said, Ashley, in the community. That's a really hard thing to come back from once that damage is done. And I think brokers know well that everything gets around, and eventually everyone knows what's happened in any broker's office. In addition, of course, the broker could be disciplined by the real estate commission if the commission were to find that the broker's failure to create some adequate security measures to prevent such an event amounted to incompetence by the broker. The commission has the ability to reprimand, suspend, or revoke a broker's license for incompetence. And brokers are expected to know what's happening in the realm of real estate transactions and to protect the private information of their clients. So the idea of these scams has been out for a while now. There's been a lot of media coverage about it. There's been a lot of attention paid to it. And now that all of the scammers and hackers seem to be concentrating more on real estate brokers, they should be aware of what's going on and taking measures to protect their clients' information and their clients' money.
I had emailed, and they finally just got
Beyond
back to me.
that, a broker who
number to
has
call, and I'm now
used inadequate systems in communication may very well be liable in a civil lawsuit. That type of liability goes beyond just losing your license or your reputation. It can mean tens of thousands of dollars or more in compensation to a victim.
courts, I think, are likely going to look at the security measures that were or were not in place at the time of the hack and the reasonableness of the broker's procedures, including the steps they took in reviewing any communication of wire instructions or transfers, and whatever steps they may have taken in verifying authenticity of email. For instance, did the broker double check the email address of the sender and detect any differences that they should have detected in the email address from that particular sender? Were there some grammatical errors that might have clued them in that this was a fraudulent email that they may have received or that they're passing along? Or is the email from a different time zone? That's another thing to look at that might indicate that something that they're receiving isn't coming from the source they believe it to be coming from. Did they confirm wire instructions? Did they educate their clients on confirming wire instructions? Those are all things that courts may look at. I am aware of several cases that are currently moving through the court system in California and in Colorado right now that involve real estate brokers. And if we have a minute, I'll tell you just a little brief summary of those. In one particular case, which is First American Title Company versus Zapata et al., the title company was suing a broker with PZ Realty for negligence and violation of a California code that required the broker to implement and maintain reasonable security procedures to protect a client's personal information from unauthorized access or use, modification, or disclosure. An email appeared to come from the agent directing First American to wire the seller's proceeds to a bank account with Chase Bank. And First American did as they were instructed, but the account did not belong to the seller. That case is still out there now. In Denver, Colorado, there was a couple that filed a lawsuit against their mortgage lender, title company, and real estate firm, and the individual broker, all for failing to properly secure personal information after an email came from someone reporting to be from the title company requesting a wire transfer of about $275,000 in order to close. That case is also still pending. And then there's a third case I know about out of San Francisco where we're talking about $500,000 in money that was fraudulently wired based on an email from the real estate broker's account. So I think we've got some case law that is being made out there now, and real estate brokers are going to find that they are the target of more and more lawsuits if they're not protecting their clients' information.
Peter, in addition to reputation and lawsuits, what are some additional consequences a lawyer might face if they are caught up in a wire fraud scam?
So in addition to the potential disciplinary action that we spoke of, you can kind of guess that if a seller did not receive their funds, the seller didn't do anything to not receive them, they just didn't get their funds, they're going to sue everyone under the sun until they get them. And rightfully so. I'd be pretty upset too if I didn't receive my closing funds. And so the lawyer's just going to be right in the middle of all that. They might get sued personally. They might, have to try to bring in their insurance programs. They might have to, tack on, fight the bank and see if the bank had any liability. But you can guess that everyone is going to get sued until the seller tries, gets their money. And so that's really the first thing that you're going to have to worry about is any potential liability that comes on you. There is an ethics opinion that talks about what is a lawyer's professional responsibility when a third party steals from their trust account, and it goes through 5 or 6 different inquiries that talk about someone hacking into your system and initiating the wire themselves, someone forging checks, and what are your duties there, and it finds that you don't have a duty to reimburse the account on most of those situations, but it does get to this particular scenario down in inquiry opinion number 5 that talks about someone spoofing emails and directing wires to other places via email. And in the scenario, the lawyer didn't do any sort of authentication of the email or verification. They just followed the email that they received. And this opinion, the question asks, do they have a professional responsibility? Does the lawyer have a professional responsibility to replace the stolen funds while pursuing other legal remedies? And the opinion says yes, that if lawyers are not using reasonable care to prevent third parties from gaining access to the account, then they have a professional responsibility to replenish those funds while trying to recover them in other ways. And I don't know how many of us in practice have a couple $100,000 available to be able to do that. And so that's really a scary thing there, but that's why reasonable care is so important. There's always going to be a new twist to this scam that happens. There's going to be new twists forever on all these types of scams. They may always be one step ahead of us in terms of what we know and how to stop it. But some of these basic ones that have been around for a couple years now that are just reasonable care would have clearly stopped by doing some sort of verification of the emails that you're getting. That's the standard of care has changed, and that cannot be considered reasonable at this point.
I was going to say, Peter, I review applications here at Lawyers Mutual, and one thing that people put on there is their disciplinary actions. And I'm seeing the state bar every time it's an outgoing wire fraud, they're opening a coverage investigation. And they are opening coverage investigations for some of the incoming wire fraud also. So I don't know how many of those that I have seen, but it is happening almost every time that there's a known wire fraud with an attorney involved.
Yeah, we are opening a grievance investigation on every one of these outgoing ones to make sure that we get proper responses from lawyers and get the right data and documents to be able to prove either way if the lawyer was being reasonable. And I can almost assure you that over the next few meetings and over the next few years, discipline on this kind of stuff is going to keep going up. There's always the chance that lawyers are now, at some point soon to be given public discipline for falling for these kinds of scams, and that's certainly not something you want to appear on on the internet when people search your names. The other thing that lawyers need to do if these things were to happen is they do have a duty to self-report to the state bar if there's been some sort of theft from their accounts. And so you are required to notify us. That's very important. And you have to notify your clients about this situation. Try to advise them on what the consequences of this may be. Try to mitigate those consequences. Defer actions if necessary to protect clients that are dealing with this. It says that in this ethics opinion, if necessary, stop payments may be required if there's funds that aren't available, or if the account's been depleted, or whatever it is. You have a duty to try to mitigate and rectify the situation. It's certainly don't want to get to that point, but we have many times now had these calls from lawyers that say, this has happened, what do I need to do? And we start going down this path.
Well, to all the real estate brokers out there, please know that Peter is probably the one that we are all most scared of and want to stay away from. And I know it's been very frustrating to all of y'all how probably each law firm has some different requirements of how wires are handled and what's going on. What you might not know is that the majority of law firms here in North Carolina, most of us obtain our malpractice insurance from Lawyers Mutual. And just about a week ago, Lawyers Mutual issued a statement that beginning on November 1st, there's going to be some changes that their attorneys under their policy will have to make. It says that our malpractice policies will exclude any potential coverage for wire fraud scams. Kind of scary for all of us lawyers. However, they also stated that lawyers' malpractice policies may have an endorsement to include potential coverage provided that the lawyers meet their safe harbor requirements. So we want Troy to discuss what these safe harbors are, not only so that the law firms can implement them, but so that real estate brokers, you can start anticipating them at the law firms that you are closing at.
Thank you. Again, this is for all policies that reissue effective November 1. So starting in a couple of weeks, we're going to make sure our policy is very clear as far as what is covered and is not. And just to step back, we'll frequently get asked, are these matters covered by the policy? And the question is, it's really difficult unless we go into the safe harbor. And the problem is going to be that malpractice policies, whether the real estate brokers or the attorneys, are designed to cover losses that are caused primarily by a negligent act, by a mistake, an error, or an omission. They're not designed to cover in situations in which there is a fraudulent or criminal act. Those are designed to be covered primarily by crime policies. Now, can you find a way that would be covered under errors or omissions or under a different type of policy? And the question is, well, right now we don't know because these are all relatively new and the court decisions are not coming out very frequently right now. And as they come out, all insurers across the country start changing their policies. What we are doing is we want to make sure it's clear that we will cover these if you follow the safe harbors. And the first one is for incoming wires. Basically, we would like, preferably at the engagement letter stage, that the client be provided a notice of the potential causes of problems, and we have suggested language available on our website, and that be signed by the client and returned to the office prior to anywhere getting close to the wiring stage. So when the client first comes in, or when the realtor first emails the contract to your attention, an engagement letter goes out, it has the warning, it's signed by the buyer or the seller, depending upon which engagement letter is appropriate, returned to the office. And if that's the situation and we have that, then we would cover under our policy, or we subject to all of the terms and conditions of the policy. Make sure you know I do have a law degree, and I add that language. We would look at coverage in that situation. For outgoing wires, we're going to require an original and notarized directive directing the attorney on how to send the wire.
Unusual anymore.
The specific language in the endorsement, and it's available on our website, is we want something like this in your engagement letter that will be signed and returned, advising the client to contact the office before sending any wire, and if they fail to do so, their funds could be endangered. Now, I always, I do claims for a living, and I don't know how many claims I've had where an attorney has botched a mechanics lien because they created their own form. When the statute says the form should look substantially like this, I'm going to feel the same way about this. We gave you the language that it should substantially look like. We would love for it to look exactly like this, and it would, then we don't have to worry about what the word substantially means between a bunch of attorneys. So just again, that should go out in the engagement letter. We know that sending engagement letters is an additional step. We love engagement letters because we don't really have that many claims when there's engagement letters. And I'm somewhat worried about job security. If attorneys all start using engagement letters, I don't know if there'll be a need for that many real estate claims attorneys, but that's a sacrifice I think we're all willing to make. The next thing is for the outgoing safe harbor, and you can get this on the Best Practices Task Force. Nancy Ferguson has uploaded this form, and this is a sample form directing the attorney's office on how to wire the funds. I created this myself. If anyone has any issues with it, please contact me directly. I'm sure it's something we can modify. This is just a suggested form. And I have the whole form available. Obviously, you can't read it on your computer screen. But the important language is right there. It's an outgoing, it's just a directive. Now, ideally, this will be signed at the closing table. If you're doing a traditional closing ceremony where both the buyer and seller are present, this will be signed in front of your office. And I know of no wire fraud anywhere in the United States, and I follow this to the best of my ability, where someone is giving wiring instructions at a closing table and it's gone bad. It's always worked. That's the best case scenario. And, as a liability guy, I've got a pretty good contributory negligence argument if that turns out to be fraudulent. I like that argument. So we really love for that to happen. However, we do understand, and especially in certain markets, the number of times that the seller physically attends the closing is limited. However, the best way to do that, and there's no additional burden to have it notarized, is to have the seller return it along with the deed and lien waiver and other forms as part of the closing package. You're going to have to get a bunch of stuff notarized. The notary can just put the stamp on there one more time. And again, we know of no situation when this form or a similar form was returned with transactional documents that they've been fraudulent. If this is done, then we think we would be within the safe harbor, and we would not assert a coverage opinion assuming you otherwise qualify for coverage under our policy. Again, that's available in the Best Practices Task Force, or you're welcome to contact us here at Lawyers Mutual, and I'll be happy to email it out. And again, I do take suggestions. I'm not married to the form. It obviously will have to be modified to fit your practice needs.
So to summarize, Troy, what
all of us real estate lawyers, really for best practices, should be doing, and what the real estate brokers should be seeing their closing attorney doing, is sending out engagement letters, correct?
Yes.
And including these wiring instructions in there with this language, and have the client initial that and send it back.
Correct. That will need to be signed by the client.
Okay. And then the real estate attorneys should be doing, and the real estate broker should see their attorney doing, is having the seller's wiring instructions signed and notarized.
Correct.
Okay.
And even if they're signed and notarized, we still want people to follow the best practices, which if you get the wiring, now if they're signed in your presence, I think that's about as good of a verification as you need.
Okay.
However, if they do come back with the closing package, there's no reason for them still not to be verified. Now, we would not have a coverage issue, but again, the whole goal of this is to prevent the wire fraud, and so it should happen. And one way that we could, I think real estate brokers could help us immensely is letting the clients know that this is going to happen, that sometime around closing that they should expect a phone call from the closing attorney to verify the wiring instructions. We're getting a lot of pushback that people are, the real estate brokers do not want the attorneys contacting clients directly. I can go back, who is your client? It's not the broker, it's the people, it's the buyer and probably the seller if you're not using appropriate engagement letters. And I don't know how there can be cutoff, but we would really appreciate the support of the real estate brokerage community in understanding that there needs to be some direct communication and for people to expect and to take those calls. We know it's a busy time. People are packing U-Haul trailers, but at the same time, this is kind of important and needs to be given the appropriate priority.
We have found in our office that we get a lot of pushback from sellers, and they're not prepared to verify their wiring instructions. So we've decided that when we're changing our engagement letters to include your instructions and our wiring instructions, that we're going to change with our seller terms of terms of service. We're going to say, be prepared for this phone call. We're just checking on your, to make sure that we're all on the same page about where to wire this money. So, yes, we definitely want them to be expecting that call and be prepared to verify their wiring instructions.
Good. And just, understand this is something we have given hours upon hours upon hours of debate internally to do this. And this is our best recommendation on how to prevent these from happening.
Earlier you had mentioned crime insurance, I believe. Can you talk about some other tools that are available for law firms to protect themselves and their clients from wire fraud?
Yes, and again, there are several threats facing both real estate brokers and also real estate attorneys, and the wire fraud is just a small segment of that. As I mentioned, that when there's a crime involved, traditionally speaking, professional malpractice or errors and omissions coverage is not going to cover these things. And there are specific insurance products that are available. There's a picture on your screen of a brochure that we met out to every law firm that we insured. It's published by the American Bar Association. It talks about coverages that are available. The main point that I want to emphasize about these type of products, and Peter hinted at it earlier, is that this is an emerging market. And one problem that we have as real estate attorneys, we're probably most familiar with the title insurance policy. And every title insurance policy has identical language for the most part. Whether you purchase it through Fidelity, you purchase it through First American or Investors, the language is going to be all going to be the same. And so we would strongly, we're used to people things being the same. The same thing with our professional liability policy. It's depending upon who you go with. There may be some minor differences, but for the most part, the policies are all the same. Key working with an appropriate broker, because this is not going to be the same policy that you have year after year. The coverages are changing and they can be woven together. We have prepared a document that's available on the Best Practices Task Force that kind of explains the differences in the coverages, whether you get cyber or crime or a combination of both, and that is available for download on the Best Practices Task Force to kind of give a little bit of It also has the ability to questions that you could ask. And these questions are also highlighted in the next slide. I'm going to advance right here. I'm not going to go over those just for the sake of time, but a couple of key points are.
Go ahead, Troy.
Okay, good deal. So those are some questions that we think are available, and obviously we have a vested interest here at Lawyers Mutual, and we do have an insurance agency
That being said, this is really not a product that you probably need to get from your State Farm guy right down the street. Not the guy's not confident for your home life or auto, but this needs to be something that is a substantial portion of their book of business, because right now it is just not standard. I attended a cyber conference about a month ago, and this was for very large organizations that are able to negotiate terms. And I was saying, that's not really what we typically see in the line of business that I have. Is there any standardization coming? And across the panel, I just got a no. And they all laughed. They said that's just not happening. That's going to be at least a decade away before the policies are anything close to typical. So working with a broker that has relationships with different insurance companies and is able to weave together the policy can be advantageous, and the price differential can be absolutely substantial. Right now, sometimes you're able to add coverages that would be appropriate for your practice areas. For this is for both the real estate attorneys and also brokers. You might be able to add it to your existing general liability or business owner plan. And if that's the case, it can be a substantial discount, and you might be able to get coverages that have adequate coverage for you.
Thank you for that information, Troy. Peter, I think this next slide is yours, about what can law firms do to protect themselves from wire fraud.
Well, I think we've talked about all the different tips that they can do to protect against wire fraud. I will kind of relay a personal experience that I just had a couple months ago. I just sold and bought a home, and probably the last person you would want to be chosen as a client for a lawyer in a closing. But in that process, I was probably hyper paranoid, and everything I wrote to the law firm said, I will never ask to change my method of disbursement. Please just create a check and I'll come pick it up. And because I was just too afraid of anything else, I won't change anything. And so that worked out fine. But one thing I noticed is, and it kind of struck me, was don't rely on the institutions to do everything right, because they don't always do it right. I won't name the bank, but with the bank I was dealing with, there was, every time that they sent me a document, it was an online portal to log into to be able to view it, and it was working great, except for when it was time to give me all of my closing documents and show me the entire statement. They said, all of your closing documents are available online through the portal. For your convenience, we're also attaching it to this email via PDF. And you're thinking, what's the point of having all this, online secure portal if then they're trying to be helpful to you and make it easy for you? And that, to me, is where law firms get in trouble, is that you have a innate and instinctive desire to do things that your client asks you to do. The paralegal that is getting the emails, it's not always the lawyer or the one that's getting the calls. They have an instinctive desire to do what's being asked, and a gut to trust that what they're getting is really from the client or from the seller or buyer. And so you have to fight that trust now, because it really is too dangerous to just assume that everything is good. One thing that we recommend, and there's been a lot of different things out there. I think the language that Lawyers Mutual has out is fantastic. But along those same lines, there have been different tips that we've posted and put in the journal throughout the last couple of years. And one of them is setting up a policy in your firm that you are doing every single time you're receiving and issuing a wire. Have a checklist or a notepad of something that you're filling out every time that there's a wire. Different insurance companies have different aids here. The one I've been given a stack of and give out is the one from Investors Title that's acronymed WIRE, and it's what I require every time. Those kind of things. There's different agencies that have all these different types of support, but just for an example one, you fill out this pad, and every single time you fill out a checklist that shows what you're doing, who you talked to, how you received it, what was the name, how did you confirm it, how did you verify delivery, and it has to be something that becomes so ingrained in your office that you're doing it every single time, that you're never deviating from, because it's that one time that someone tricks you into deviating from that plan that you fall for it. And the other thing to tell the North Carolina lawyers here is that you might assume that you're never going to fall for these because you guys are a smart, sophisticated law firm. It's only these silly, idiot lawyers that are falling for it, or the unsophisticated ones, but it's not. And we have experience with it. It's the extremely good law firms. It's the law firms with good reputations. It's the advanced tech-savvy law firms. It's hitting everyone. So if you think it's not going to be you, you're wrong. I think there's a quote from the former FBI director that says, something about it. It's not a matter of if you'll be a victim of cyber fraud. It's a matter of when you'll be a victim of cyber fraud.
Janet, let's hear about real estate brokers. What can they do to avoid? So real estate brokers, particularly are brokers in charge, and for the lawyers, I'll say brokers in charge are the brokers who are in charge of the office. They're the ones that are responsible for the supervision of provisional brokers and have certain other duties of responsibility, including the trust account in the brokerage firm. So our brokers in charge really ought to create some sort of standard communication protocol designed to avoid wire fraud, and they should be providing training for all the brokers who are affiliated with their firms, their provisional brokers and full brokers alike, and for their staff. As Peter said, a lot of times these emails are coming to staff members or assistants, and they need to understand what's going on with that too. They need to understand how their email account might be hacked and then monitored for information about an upcoming real estate transaction. Our brokers in charge ought to also require all of the brokers associated with their firm to educate their clients more thoroughly on wire fraud and the potential loss that could occur if they are engaging in wiring money without adequate protections in place. The National Association of Realtors recommends that real estate brokers add a wire fraud email notice to the broker's email signature line that basically says in some bold type to never trust wiring instructions sent via email and always confirm wiring instructions in person or via telephone using a trusted and verified number like we've talked about earlier, not the number that comes in the fraudulent email. That disclosure would be made every time an email is sent by the broker, and hopefully the client might read it at least one time. Brokers in charge also should require that all of their brokers affiliated with their firms use secure internet providers or systems that utilize secure methods of communication. A good office policy for a firm is going to go a long way in lessening the potential liability for the firm that could be there as well as for the individual brokers. And then, of course, our brokers all ought to look into the insurance policies that were discussed earlier by Troy, see if they might be able to get coverage should they have a breach of this type occur in their office.
Janet, looking at some of the questions that are coming in, one of the questions was, is the Real Estate Commission considering requiring real estate brokers to use encrypted emails?
The Commission has had some limited discussion on whether or not that is a good idea or not. They have not made a decision to move in that direction yet. I can't say that they won't in the future. These are hot topics that we talk about every month when they meet, and at any point in time they could change course and decide that they do need to go in that direction. We'll see how it goes and where they are. Commission changes from time to time. Members change. Their viewpoints on things change. But this is definitely a topic that has been discussed at commission meetings and continues to be discussed.
All right. Looking at one of these other questions that's come in, one of my favorites is, why all this talk about wires? Why don't we just go back to good old certified checks at closing? Troy, could you speak to certified checks?
There's actually a matter on the listserv that I posted about it earlier this week, I believe, about certified checks. And the problem with certified checks is, there's three problems. The first two, what I'm going to concentrate on, is that, one, you're assuming the check is legitimate.
and two, that you're assuming that it will be honored. And those are two things that are probably not in the best, it's not things you learn in law school, is to predict the financial viability of a lending institution. And it's been a while since we've had a major bank failure, but the whole reason these ethic rules exist is because of the saving and loans crisis that happened not too long ago. I mean, it's been some of our careers. And so the likelihood of a bank failure is something that is legitimate, and it's something that you're making a personal guarantee upon if it is. The other thing is whether or not the certified check is actually legitimate and not fraudulent itself. And I've had claims where we have had the original instrument that was later dishonored. It was taken to a mega bank teller, and the mega bank teller said, I have some suspicions, and could not tell whether or not it was legitimate or not. Check printing technology has advanced to the point that there is no possible way to know if it is legitimate. So you are basically taking the risk. If you put those funds in there and do not wait for them to be, the technical term is irrevocably credited, then you are making a personal guarantee that bank is going to survive and that check is not fraudulent. Also, you also are only allowed to disperse under the Good Fund Settlement Act. You are allowed to disperse upon an official bank check, but you are not required to disperse. And I want to be clear that there's no requirement that you accept another attorney's trust account check. There's no requirement you take an official bank check or even a certified check. That is completely in your discretion. But you're only allowed to disperse when there's been a provisional credit. And when exactly the provisional credit is given varies by banking institutions. There was some recent discussion on the Real Property Listserv about this that I will reference everybody to. But I would just be highly, highly cautious. The days of being able to consider a certified check close to cash are just not there any longer.
And this is Peter talking. There is an ethics opinion from the State Bar that allows lawyers to disperse on provisional credit for items that are listed in the Good Fund Settlement Act. But the caveats for it are you need to be virtually certain that the check is going to clear, because if it doesn't clear and you've advanced those funds on provisional credit and the check doesn't clear, then you are professionally responsible for any deficit created in your trust account. And you don't want that.
That's RPC 191, and it also says, a quote, and I'm going to not quote it exactly, but pretty close, is that an attorney should be very cautious dispersing on certified funds that they do not have the ability to reimburse due to their own liquidity. And so I personally don't know what my number was. It wasn't close to $250,000 that I would be able to quickly put the funds back into the trust account. So I just strongly discourage that. We do not like wires because of those security risks. However, they can be done safely and securely, and there's really no way to make sure a certified check is legitimate until you wait several days at a minimum for it to completely clear.
I will say that I've had a colleague that accepted a very large down payment and dispersed relying upon a certified check from a national bank, and when that national bank decided a few days later not to honor it, they have to go and take out an equity line or however they can come up with the cash to replace that money, and not something that real estate lawyers want to be on the hook for. So I just hope everybody understands that while we're not accepting certified checks now and while we do need wires. One of the other questions that has come in is it appropriate to email an engagement letter? And Troy and I actually had this talk earlier because we were discussing putting the wiring instructions in the engagement letter. I will say in our office, we won't open a file until we have that engagement letter back and know that this person really does want to go through with the closing and they've engaged us to get started and they're going to pay us for the time that we're getting ready to put into this file. Troy and I discussed, if I send this engagement letter through a secure email, that this client that we may not have had contact with yet might be a bit suspicious of that, and we think that it is safe to send this via unsecure email because we're going to receive it back from them signed and initialed and be making contact with them thereafter. Do you agree, Troy?
Right. I mean, is there a risk? And the answer is yes, there is a risk, but this should be early on in the transaction. Again, usually accounts are being monitored. If it's the individual buyer's account that's being monitored, the term wire has not been used elsewhere. And again, it's not foolproof. This is the best practice that we know. And so having an engagement letter, I think someone wrote in saying that mailing it is not practical, and I completely agree. Mm-hmm. Mailing it, first of all, someone likely is moving, so they may not have a real address where the mail is going to get to, or it's maybe forwarded or whatever. So, no, we completely understand. This should just be done early in the transaction. Waiting until the end, a day or two before closing, to start sending out these warnings, you're way, way, way too late in the transaction. First of all, if it is being monitored by a hacker, they're now are keyed in. When they have a closing date, things really start magically happening. They start monitoring the account in much more detail, and maybe get away from a machine reading the emails, looking for keywords, to actually someone sitting down in an internet cafe reading the emails. So again, early on in the transaction is the best we have now. We consider that acceptable.
One of the other questions we have comes from Greg Strickland, and he wanted to ask Peter what your thoughts are on iTrax.
iTrax is one of the types of services that allows for real-time monitoring and reconciliations of your trust accounts. It's also called Rhino, different other terms, and it really is a useful tool for lawyers to link their accounts to this service that's constantly looking for red flags, or checks without attributions, or checks made payable to your employees, or types of things that cause negative balances. Those types of things that's constantly monitoring in real time, I think also probably helps comply with some of the Alta best practices on having your accounts reconciled. I'm not entirely sure that this really would stop you from falling for one of these scams. If you would tell the bank to initiate a wire, then the bank has no reason to know that it is not legitimate. And that's what we always used to hear back from the banks was, well, you directed me to send this wire, and I sent the wire. And so now it certainly is better than not having it. All these types of tools like Positive Pay and iTrax are good safety measures to have on your accounts, and we don't require them, but we do think that they are the types of tools that could show that you are taking reasonable care to protect your accounts, and properly manage your online banking. And I've seen the reports that iTrax and Rhino, that they create, and they're very detailed and seem to satisfy all of our kind of reconciliation requirements at the bar.
To all the attorneys out there, if you're not using it, I'd highly recommend it. I don't know how our office functioned without it.
We know of several situations where attorneys' trust accounts and checks have been stolen. Without having Positive Pay, people would have started bouncing checks, because the hackers will get a hold of the checks and they'll just start writing them everywhere. And there's no way to know that it's legitimate. The Alta best practices require daily reconciliation for receipts and disbursements. And I do not know how a law firm could be in compliance without using one of the software providers out there. I just don't. We ask that in our underwriting application, and there's a consequence or a reward, maybe be a better way to say that, if you are certifying your compliance with Alta best practices. And I just don't know how you could be without that.
I think we have a few more minutes here. Janet, you and I have been talking earlier about wire fraud is something you've come across, and I know we've gotten a request for the craziest example of wire fraud. So can you share your most recent one that you've heard about?
Well, I can tell you, if we haven't scared the pants off the real estate brokers yet, this might do it, especially if there are any property managers out there. One of the things that I've heard about is and I'm going to try to explain this as best I can. I'm not a tech person, but my understanding is there's a type of wire fraud that is going on involving property managers, where the fraudsters are infiltrating systems, going through emails the same way we've discussed earlier, by sending these emails, getting you to click on a link, getting you to download something, look at an attachment, and they're in your system. And then what they are doing with the property managers is going into, a lot of our property managers make payouts to their clients every month for rents received using ACH transactions, and they're done in batches. And so they will create these batch files that then go to the bank, and the payments get made. Somehow some magic happens, and the payments get made, and they go to all the individual owners' accounts. And what they are doing is getting into these files and going through the list of ACH transactions that are going to be sent out, and they are changing the numbers on the accounts where the wires are going, but they're not changing every one, they're changing every so many. so that it's not detected as easily if they changed the entire batch. So property managers who have hundreds of owners that they're sending rental proceeds to every month may be hit with, half of their owners' proceeds being sent somewhere else, diverted and sent somewhere else, and they're gone. And it may take a while for them to realize what's happened, maybe beyond the 24 to 48 hours that we've talked about earlier, and there are no closing attorneys involved. This is a property management transaction, so we're talking about the real estate broker on his own or her own with that kind of wire fraud happening. It can be devastating.
Yeah. I definitely don't think you would find out in time to get the funds back in that situation.
No, because often the owner doesn't notice they haven't received the funds for several days.
Right. All right, folks, it's almost 1:30, but before you go, we want to thank RELANC, the Real Estate Lawyers Association of North Carolina. If you're an attorney, please be sure to join RELANC, but if you're a real estate broker, please be sure to refer your clients to a RELANC member for closing. RELANC members are committed to upholding the best practices as required of real estate lawyers. Thank you, too, to the North Carolina Bar Association and the North Carolina Land Title Association, as well as the North Carolina Closing Attorney Best Practices Task Force. And finally, a big thank you to all of today's panelists. Please note that this webinar and the slides will be available on the task force website and the RELANC website. Thank you again, and have a great afternoon.
There are a few people that had questions that were not asked. We just didn't get to it. We'll contact you later. I'll answer them all by email. Thank you.
Thank you.